Dear students of the e-commerce class, welcome to Section 2, International E-commerce and Consumers Protection. In this second section, the legal aspects of electronic commerce will be addressed, both internationally and nationally. First, international legal instruments regulating electronic commerce will be examined. Second, we will study Colombian legislation on e-commerce, including Law 527 of 1999, Law 1480 of 2011, and Law 1581 of 2012. At the international level, legal instruments have been established such as the UNCITRAL Model Law on Electronic Commerce, which consists of a set of rules that seek to establish an adequate legal framework for electronic commerce. One of the most important aspects of this act is functional equivalence, which states that electronic documents and messages have the same legal value as paper documents and messages. The United Nations Convention on the Use of Electronic Communications in International Contracts, which establishes rules for the use of electronic means in the conclusion of international contracts. The UNCITRAL Model Law on Electronic Signatures, which establishes rules for the use of electronic signatures in international contracts. On the other hand, Law 527 of 1999, Law 1480 of 2011, and Law 1581 of 2012 establish clear rules for conducting commercial transactions online in Colombia and are fundamental to guarantee security and confidentiality of transactions, as well as to protect the rights of consumers and companies. These instruments seek to promote trust and security in e-commerce, establish standards for the legal recognition of electronic transactions, and reduce barriers to international trade. In addition, these instruments focus on specific aspects of e-commerce, such as electronic signature, personal data protection, and dispute resolution. In this section, we will examine the most relevant international legal instruments on e-commerce. The UNCITRAL Model Law on Electronic Commerce is a guide for the development of laws and regulations on electronic commerce at the national and international levels. It was adopted by the United Nations General Assembly in 1996. The law establishes a legal framework for commercial transactions conducted by electronic means and addresses issues such as the formation and validity of electronic contracts, identification of parties, security of transactions, non-discrimination, technological neutrality, data message, and acknowledgement of receipt to determine the place and time of sending and receiving data messages. The UNCITRAL Model Law on Electronic Commerce promotes functional equivalence, which recognizes electronic means as equivalent to physical means. These ensure that contracts and electronic documents have the same legal value as those made on paper, thus avoiding discrimination based on how they were created. According to Article 6, it is established that formal requirements can be met with electronic documents as long as they are accessible and preservable. Article 7 recognizes the functional equivalence of electronic signatures, provided that they perform the functions of a handwritten signature. Finally, Article 8 establishes functional equivalence between originals and copies of electronic documents, provided that the copy is accurate to the original. The United Nations Convention on the Use of Electronic Communications in International Contracts is an international treaty adopted in 2005 that establishes uniform rules for the use of electronic communications in international contracts. The convention applies to any electronic communication between parties who have agreed to perform the contract using electronic means, either in whole or in part. The main objective of the convention is to provide a clear and predictable legal framework for commercial transactions conducted by electronic means in order to promote the use of information and communication technologies in international trade. The Convention establishes rules for the formation and validity of international contracts made by electronic means. These rules include provisions on electronic offer and acceptance, electronic confirmation of contracts, and the use of electronic means for signing contracts. The convention provides that, unless otherwise agreed between the parties, the mere fact that an offer or acceptance is made by electronic means shall not affect its validity. It also lays down clear rules on the confirmation of contracts and how electronic signatures should be considered. The Ancestral Model Law on Electronic Signatures, adopted in 2001, seeks to establish a legal framework for the use of electronic signatures, ensuring their equivalence with handwritten signatures. This law defines different levels of electronic signature and its requirements. The most basic level is the simple electronic signature, which requires identification with the signatory and association with the data message. The intermediate level is the advanced electronic signature, which has additional requirements such as signatory authentication and message integrity. The highest level is the qualified electronic signature, which meets the same requirements as a handwritten signature and is issued through a qualified device. The law also addresses the responsibility of the signatory and the certification service provider, who must ensure the integrity and authenticity of the electronic signature. In Colombia, e-commerce has experienced significant growth in recent years, becoming one of the most popular ways to do business. The need to regulate this activity has led the country to implement various legal norms that seek to protect consumers and promote the development of the sector. Law 527 of 1999, also known as the Electronic Commerce Law, is a Colombian law that establishes the legal framework for commercial transactions conducted through electronic means. This law is of great importance in the development of the digital economy in Colombia, as it provides the necessary legal basis for electronic commerce and guaranteed security and confidentiality of information transmitted online. Law 1480 of 2011, known as the Consumer Statute, is a norm that regulates the relations between suppliers of goods and services and consumers in Colombia. As for e-commerce, the law establishes a series of requirements that suppliers must meet when offering their products or services online. Law 1581 of 2012 is a norm that establishes the regulatory framework for the protection of personal data in Colombia. This law is of great importance in the context of e-commerce, as personal data is the raw material of online business transactions. The law establishes the principles, rights, and duties that both companies and users must follow in the handling of personal data.
Universidad Santo Tomás, institución vigilada por el Ministerio de Educación Nacional.